Good morning, everybody. Welcome to day one of the Karen Reed trial. Where are we? Where are we? All right, those of you who are maybe very familiar with this trial, some of you maybe have heard about the trial, not know too much about it. Some of you may have watched a large part of the first part of the trial. Some of you may have watched with some of my peers this trial who are likely streaming now. I don't even know who's covering it now. And if you're a fan of this show, you probably know that when the Karen Reed trial part one, which ended up in a mistrial, hung jury, was ongoing, I was AWOL from it. I was not following it. I don't remember what was going on in my life at that point in time. But my familiarity with this case, Karen Reed trial, and her defense of her purported murder, police officer John O'Keefe, I feel walking into this trial gives me a unique perspective. I have an overall idea as to how she's charged with vehicular homicide, drinking and driving, and running over her boyfriend, which is a little bit strange. There's a lot of questions I have with respect to the underlying elements of that. I know there are allegations from the defense that she was framed, that they were covering up, that they were trying to mask their own nefarious activity, that he was actually a victim of his fellow brothers in blue. And what I think I'm able to offer here is, as we're going through this trial, I have zero vested interest in either side, either prosecution or the state. So in that sense, I'm coming at this as someone who understands the law, who's watching both the work of the prosecution, work of the defense, and telling you what I think and how well they're doing as it's coming across. So I have no preconceptions whatsoever as to her guilt or innocence. And I think that probably makes me a better gauge as to how they're doing before this jury that they need to convince. I hope it works out that way. I don't know, but I'll be able to give you my perspective on that. So with that in mind, let's see where we're at here. It's Karen Reed trial. Let's see what we got going on here. That was not mine. This will give you a little bit more background here as we're getting on into it. Please let me know if my volumes are good. So that's always important.
NBC 10's Katie Benoit reports.
Jury selection will start here in Dedham tomorrow morning. Today, the judge ruled on what type of defense Karen Reed's legal team can use in the retrial. Reed is accused of backing into her boyfriend, Boston police officer John O'Keefe, and leaving him to die outside a home in 2022. But her defense claims that she was framed and wants to use what is known as the third-party culprit defense. Today, Judge Beverly Cannoni ruled it will be allowed in part, allowing the defense to possibly point a finger at Brian Albert and Brian Higgins, who were both at the Canton house party that night, but not Colin Albert.
The question for the court was, is there actual probative value that these third-party culprits may have committed this crime, or is the defense just trying to muddy the waters and confuse the jury? And the judge seems to be leaning towards, no, this is just confusing the jury. So she's allowing them potentially to point the finger at two third-party culprits, but they're not allowed to mention it in an opening statement, and they have to flesh out their arguments throughout the trial before she's going to let that in.
Cannoni also ruling today a former FBI agent, Michael Easter, will not be allowed to testify. The defense wanted him to give his opinion on the police investigation. Multiple members of law enforcement faced
So that would be him serving as an expert witness.
disciplinary action after Reed's mistrial.
It hurts, but it's not a huge blow necessarily, because what the judge's ruling says basically is your expert witness was just going to come in here and testify to things that the jury already knows. It's in their common sense. So you don't need an expert to come in and say that they didn't follow procedures.
Finding a jury could take a
That sounds kind of crazy. I'm not going to kid you. That sounds kind of crazy. What? It's already in their common knowledge?
Happening today, jury selection will begin in the second.
Okay.
It was the night before the retrial, and all
What's this? What the hell is that? That's not what I wanted. The reason why that's kind of ridiculous also is because an expert, this is in the Star. I thought Courtroom was covering this for a second. The reason let me just pull it up here. The reason that sounds kind of ridiculous is because think about this for a second. Even if you know, and I've heard all about how they collected stuff in some evidence in red Solo cups, which obviously sounds ridiculous, but to understand as far as the impact that has on the credibility, the impact that has on how this thing unfolds. Yeah. That's why I was late. And no, I haven't found them yet. They're somewhere. Yeah, so the impact that has as far as to tainting the evidence, that is leaves them a little bit in the dark. Like, all right, it may not be that essential. It may not be that essential. All right, let's see what we got here. It is kind of weird that it's starting on April Fool's Day. I'm not going to kid you. It is kind of bizarre that this thing is that all it is for Judge Canoni to pick to start this thing. She goes with April Fool's Day. No. I'd be much obliged for that. Thank you. Thank you very, very much. I'm trying to find a good link. I probably should get a gauge as to where my audience sat on her guilt or innocence. I have a feeling that most of you think that if she's not guilty, at the very least, that they did a very piss poor job of presenting their evidence on the first go round. I have heard that claim from a lot of people. I was led to believe that Court TV would have it, and Court TV's live TV is not really sharing it, which is a little bit frustrating. Check C-SPAN. Oh, they're not getting to wait until 9:30. It said 9 o'clock, but they're not getting to wait till 9:30. Mm-hmm. There's a she's factually innocent. Factually innocent. As a lot of folks said. I think this was terrible police corruption, and the issues with respect to Albert Higgins, and that he was basically beaten to death by these officers. And obviously, look, if they had some sort of issue with him and ended up leaving him to die, like beating the hell out of leaving to die, doesn't seem like it would be that hard. Doesn't seem like it would be that hard to actually frame her. But we're getting ahead of ourselves. I have another 20 minutes before this thing actually gets underway. All right. I'll go through some background. I'll tell you when I read this, the first thoughts I have on this thing as it was unfolding. All right. What to know about Karen Reed's murder, retrial, and the death of her police officer boyfriend, John O'Keefe. First trial ending in a hung jury. Jury selection and retrial starts this week during a during a long and widely watched trial last year. Karen Reed prosecuted for the murder in the 2022 death of her boyfriend, Boston police officer John O'Keefe. Trial included allegations of police misconduct and a wide-ranging conspiracy among law enforcement to frame Reed in the killing, ending and the killing ended in a hung jury. Now, when they say wide-ranging conspiracy, to me it comes across as if they're trying to make it sound it's untethered from reality. That is the context that this comes across to me. When it comes to police officers, you don't need to have it be there's a concept of a wall of blue. That's it's not like this is like a police officer conspiracy is never needs to be like what anyone would call wide ranging. Wide ranging implies a whole bunch of nefarious actors who don't have any much of otherwise a close relationship with each other. But these people are all been working together and know each other for probably decades, so it doesn't feel really that wide-ranging. Jury selection in Reed's retrial on charge of secondary murder, motor vehicle manslaughter while driving under the influence and leaving the scene of a collision causing death is set to begin Tuesday in courtroom outside Boston. Here's what to know. O'Keefe, 46, had been a police officer for 16 years. He was found unresponsive on a snowy January morning outside the suburban home of Brian Albert, a now retired police officer sergeant, Boston police sergeant. O'Keefe was pronounced dead shortly thereafter. Medical examiner attributed the case to blunt force trauma to the head and hypothermia. Reed, then an equity analyst who had been dating O'Keefe for 2 years, was arrested in connection with his death days later. And that is natural. Obviously, the first person you look to is the love interest. Whoever's the love interest almost always has a hand in it. That's fair enough. That's reasonable. When Reed was tried in 2024, the Norfolk County District Attorney's Office pointed to the couple's troubled relationship as a possible motive. Okay. And the killing and accused her of striking O'Keefe outside the sergeant's home with her Lexus SUV after a heavy night of drinking. You see, this is the problem This is here's the problem here. Here's the problem here. Don't tell me that she's mad at him and then she hits him with a car. It's just not the way you kill someone if you're mad at them. And then leave them without knowing that they die. You wouldn't. That sounds like a very stupid person type of tactic. I'm going to hit this guy with my car and then leave him be. That doesn't sound like something folks would do, especially when he's right outside his cop friend's house. So you know that if you didn't finish him, he's probably going to go crawling inside and say, my girlfriend just ran me over with a car. So is it that you're saying she's drunk? If she's drunk, in that case, all right, she might have been so drunk she didn't even realize that she hit him. Fled in fear or whatever. But it seems kind of ridiculous, I don't know, to say she's angry at him, trouble relationship, as if she had an objective of seeing him dead and then did such a poor job of it. The death was not captured on camera. No eyewitnesses claim to have seen what happened, but the Assistant District Attorney Adam Lally told the jury that the vehicle data from Reed's SUV showing her traveling backward for 60 feet at 24 miles per hour outside Albert's home around the time that she was dropping O'Keefe off at a party there. So she's dropping O'Keefe off. O'Keefe's hair was found on the vehicle's bumper. The DNA was on the SUV's broken taillight. Lally told the jury the remnants of a cocktail he appeared to have left a bar with earlier that night were also found on the bumper, as were bits of what Lally described as a drinking glass. So you're telling me the remnants of a cocktail, like the drink itself, appeared to be, were on that spilled on it. All right. Okay. Reed asserted her innocence. The defense team accused Albert and others who had been at the party, including the agents of the Bureau of Alcohol, Tobacco, Firearms, and Explosives, whom Reed had exchanged flirty texts with, of fatally assaulting O'Keefe and framing Reed for the killing. Albert testified that O'Keefe never came inside his home, but that he would have been welcomed with open arms if he had. Now, should tell you that testimony which was elicited at the first trial, which should certainly be admissible, and in the second trial. It's not often that we're dealing with a retrial of a case. And this is something that's just as far as I'll tell you as an attorney, that when we talk about issues with respect to hearsay, that the key elements to hearsay, which would knock out prior statements by anyone who came and testified, should not apply in this current setting. Because in order for it to be qualified as hearsay, it has to be an out-of-court statement that is now being brought into court for the purposes of supporting the truth of the matters asserted in that statement. And seeing as how these, and so therefore, since that's specifically referring to an out-of-court statement, and this is a statement that was made in court, all of the testimony that came out earlier should be, you would think, admissible to be brought and just presented before this jury. The defense also accused the lead investigator in the case, Massachusetts State Trooper Michael Proctor, of manipulating evidence and conducting a biased investigation. Text messages introduced at trial show Proctor using offensive and derogatory language to describe Reed to family, friends, and supervisors. That is Michael Proctor right there. And they think that he was basically helped covering up for Albert. I on the whole thing, as far as like speeding backwards, assuming that they have information up to verify the speed that she's driving backwards, I'll tell you this. I've driven backwards at speeds close to 25 miles an hour. Now, maybe I wouldn't do it on a snowy day. Probably wouldn't do that on a snowy day. Now, weather would be a factor there. But I'll tell you that I've driven backwards that fast. If you know how to drive. But anyhow, Proctor had undisclosed ties to Albert. Proctor had undisclosed ties. Why is it doing that? To Albert and his family, Reed's lawyers said, and he shared investigative details with his sister, who was close friends with Albert's sister-in-law. There's been drama with Proctor, though, ever since. Proctor acknowledged discussing the case with his sister, though he said he shared only newsworthy stuff. That's what he claimed, that he shared only newsworthy stuff, and testified that his unprofessional language dehumanized Reed. But he says conduct did not compromise the integrity of the investigation. That's nice. That's what he's saying. That's nice. That's what you're saying. Not really. That's like someone who's tilted against him, so tilted against him that it ends his career, as we're about to see next. After a 9-week trial, 5 days deliberations, jury is unable to reach a unanimous verdict, and the judge Beverly Cannoni declared a mistrial. Days later, the Massachusetts State Police placed Proctor on unpaid leave over what the agency described as allegations of serious misconduct raised at trial. So you only find this serious misconduct, only finding that as because it's raised at trial. That's not a good look for the Massachusetts State Police. That's not a good look. Trooper was fired last month after a state trial. So last month he's fired after a state police trial board examined the allegations and found that he had violated agency rules by sending derogatory and defamatory texts about Reed and shared sensitive investigative details with non-law enforcement personnel. That's something that the Reed defense should be very happy to see. Proctor also drank while on duty and drove his cruiser, according to the trial board's findings. Proctor was not publicly commented on his termination. His family said the text messages prove one thing, and that's Michael is human, not corrupt, not incompetent in his role as a homicide detective, and certainly not unfit to continue to be a Massachusetts state trooper. So please make sure he gets paid his pension. Despite the Massachusetts State Police dubious and relentless efforts to find more inculpatory evidence as opposed to exculpatory, more evidence to convict her, and as Michael Proctor on his phones, computers, and cruise data, the messages on his personal phone referring to the person who killed a fellow beloved Boston police officer are all that they found, the family said. So they're saying they were trying to make him look guilty, and they still couldn't find any evidence that he screwed up this particular case or that he was corrupt here. So that's why his family is saying, you see, he must not have done it. They did a whole investigation looking at him to see whether he was framing Karen Reed, and they couldn't find anything. Separately, Reed's attorneys tried to have the case thrown out over claims that Reed was the victim of an extraordinary governmental misconduct. They also claimed her retrial amounted to double jeopardy because after the mistrial, 2 jurors told the defense team that the panel would have acquitted Reed of murder and leaving the scene of a collision causing death. Prosecutors disputed those claims. Judges have denied both claims. So now we have the prosecution brought in Hank Brennan. I think they're trying to just sort of make the defense different, the prosecution different from last time, and removed from any taints that may exist within the police officer, within the police investigation, I guess. So they brought in Boston gang. They brought in Hank Brennan, and defense team also added Victoria George, who served as an alternate juror during the first trial. That to me is crazy. So she was an alternate juror in the first trial. Now she is part of the defense team. Quote, I waited for nearly a year after the mistrial, hoping the court system would work as intended to remedy some of the wrongs in this case, she told Vanity Fair. And here's the really interesting thing. Will Proctor testified? At the time of his original testimony, he still had a job to rein him in. Now he no longer has that job. Who knows what could come out of his mouth? I doubt he's going to admit to any misconduct like that would necessarily help the Reed team. He's on either side may call him. It may be necessary to call defense counsels to authenticate defendant's numerous public statements. This is talking about Karen Reed, who has made many public appearances. Good morning. Could you please click on the rum stream? Bunch of us waiting. Thank you. The rum stream. Rum stream. Bella Stella. Giftington. Queen of recruitment bringing in 10. Count them. 10. New members of the following. God bless you. Bella's still a queen or a groom. Those who brought into the following, please bear in mind that I am not the leader. Let's make sure I am not at all the leader of the following. Following is just a group of like-minded individuals who only care about one thing, and that is greater personal growth. When you say the rum stream, if you have a link you want to share with me specifically, that would be helpful. The rum stream. You mean Rumble stream? What the heck? Rumble's not up? You mean Rumble? How is that possible? I think you might be correct, though. God bless you. God bless you. You are correct. Well, that's a problem. That is now up and going. I apologize. Those of you who remember. Don't worry, you didn't miss anything. I'm looking up Rum Stream. I don't know the hip terms you kids use today for Rumble. I don't know the hip terms you use. I don't know. But Rumble is up and going now. Rumble's going strong. Let's see. We did say that we were starting at 9. And then we're starting at 9:30. I can't say how aggravating that is. No, I never thought about a neck chain for my glasses. The problem is I don't wear them all the time. I don't wear them all the time, and I usually leave them right here. I usually leave them right here. I'm not wearing them.
New lawyers, new tactics, new trial, same charges. Boston police officer John O'Keefe is dead. His girlfriend Karen Reed is accused of his murder, but the defense says she's the victim of a massive cover-up. Now, new evidence could change everything. NBC 10 Boston is taking you back inside the courtroom, bringing you every minute of her new trial, live. Don't miss a minute as the saga unfolds. Canton Confidential, the Karen Reed murder trial. Continuing coverage streaming on the NBC 10 Boston News Channel.
All right, that sounded exciting. That sounded very exciting. Don't you? Real spinning in the snow can make it look like a vehicle is traveling much faster than it is. It might not even be moving at all. That's an interesting theory. That's a very interesting theory. I was going to say, the speed, with it being snowy, the speed of the... if in fact she's going that fast, that would be kind of crazy. That is kind of that sounds reckless in the snow. I've driven fast backwards, but in the snow I wouldn't be driving that fast backwards. For a distance of 60 feet. That does sound, but that's a really interesting theory, Matthew. That if she's spinning, her wheels are spinning out, that could reflect on her data as her going faster. Assuming that you can get some forensic evidence that indeed they would reflect that kind of speed, which is logical. It's logical that it would reflect it. That it could reflect it. No, so that's not it there. I want to see if one of you shared a link with me that you thought was a good particular link, but that has not happened as of yet. At some point today, I will find my glasses. I'm very confident of that. Everything will look much clearer. Everything in my life will be so much clearer. I think we're there. I think it's coming right here. There we go.
100 feet there. She gave a thumbs up as she walked into the courtroom, into Norfolk Superior Court there in Dedham. So let's go now to our Manash Kungwari, who is out there this morning.
Well, today will be the first day of jury selection in the Karen
This
Reed
is live
retrial.
on Boston
and
10.
One of the differences about this case is how the defense plans to defend Karen Reed. Of course, they believe she is being framed for the death of John O'Keefe. In fact, he was found dead outside of a man by the name of Brian Albert's home back in 2022. During the first trial, the defense pointed the finger at Brian Albert, his nephew Colin Albert, and a man named Brian Higgins. But Judge Beverly Cannoni just yesterday ruling there is not enough evidence to blame Colin Albert. Going on to say, if the defense is to make a case against the other two this time, they need to provide more evidence than what they did the first time. But ultimately, it's the jury that will decide if Karen Reed is guilty. And the process of selecting the 12 to make that decision starts today.
A lot of times people say that we're looking for a fair and impartial juror to be able to put them on the panel to ultimately sit. Neither side is truly looking for a fair and impartial juror. What they're really looking for are jurors that are likely able to agree with their version of the events.
And as you can see, the barriers are in place and the Karen Reed supporters have showed up. We, of course, will be keeping you updated on what happens when jury selection hearing begins at 9. Right now, reporting in Dedham, I'm Manash Kungwari.
All right, now we want to bring you live.
And I'm going to try and walk you through the nature of the questions that they're asking.
Karen Reed retrial right now. Karen Reed is in court right now. If we can bring up those pictures, you're going to see her standing there without her team of attorneys next to her. That's because, as we understand it, they are in sidebar right now. There's David Yannetti just walking back to the table. You see Elizabeth Little. There is Attorney Alan Jackson, Robert Lessie as well, and there is the prosecutor in the background. So here's what you're seeing. If this looks unfamiliar to you, this setup, it should. This is not the courtroom where the Karen Reed trial took place last time, nor will it be where the Karen Reed trial takes place this time. The retrial is going to happen in the same small courtroom there in the Norfolk Superior Courthouse as we saw the last trial. But right now, they are in the bigger courtroom in that same building. There you see Judge Beverly Cannoni and the court clerk in front of her. The reason they're in this bigger courtroom, Monica, I was actually in the courthouse yesterday and speaking to a lot of folks there. The court clerk told me that essentially the room that they do the trial in is just not big enough to handle the number of potential jurors that will be coming in and that will be impaneled. So keep in mind the numbers here. They've got 218 jurors that were summoned to report to the courthouse in Dedham. Wow. They are estimating about 175 will show up. Now, you're not going to see any of them here right right now, because what's happening is those jurors are all being staged across the street in the Registry of Deeds building, and they will be brought over group by group to be
They're not going
questioned.
to show
And
us
it sounds
the
like
jury.
proceedings are underway, so let's listen in.
You solemnly swear to make true answers to such questions that should be put forth to you by the court, so help you God. Thank you. You can have a seat now, I promise. May I call the case, Your Honor?
Not going to show us
Your
potential
Honor, this
jurors.
is 22-117, the Commonwealth versus Karen Reed.
Counsel.
Do you want counsel? Or do you want me to say?
Counsel.
Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
I'm Lyle for the Commonwealth. Good morning.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson on behalf of Karen Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
There's no Victoria George there.
Good morning, Your Honor. Victoria George on behalf of Ms. Reed.
Good morning, Ms. George.
There she
Good
is.
morning, Ms. Reed.
2 tables worth of
Karen Reed,
defense
please
counsel.
stand. Karen Reed, you are now set at the bar to be tried, and these good men and women who I shall call to pass between the Commonwealth and you upon your trial. If you'd object to anything, you must do so before they are sworn. You have a right to challenge any 16 jurors without giving reason.
16 jurors.
Okay. Good morning, jurors.
16,
My
that's
name's
a
Beverly
lot.
Canoni. I'm a judge of this court, and I want to welcome you here today and give you some idea on what you will be asked to do. So, jury service, as you know, is one of the most important duties we have as citizens. We appreciate that you're here, ready, willing, and able to serve if you're called upon to do so. And our system of justice simply does not work without you. So we thank you. This is the case of Commonwealth versus Karen Reed. The Commonwealth alleges that at approximately 6 a.m. on the morning of January 29, 2022, the Canton Police Department received a 911 call reporting an unresponsive male party in the snow outside a residence at 34 Fairview Road in that town. Officers responded and discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center, where he was subsequently pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various ways in which the Commonwealth can prove a murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These terms and the elements of the crimes will be explained to you in greater detail at the end of the case before you begin your deliberations. Now, at the outset, I would like to address the issue of public interest in this case and the duty of this court to adhere to the rule of law. John Adams said that we are a government of laws, not of men, and that the law must be deaf to the clamoring of the public. He meant that while the public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with intensity, but without the benefit of having heard or seen any evidence at all. The law works in a different way, and the difference is crucial to our system of justice. The jurors selected for this trial will hear and judge the evidence. They will decide what the facts are, and where the evidence is contested, they will determine where the truth lies. Ultimately, the jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this criminal trial will be decided by an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, the rule of law will be upheld.
And you got to imagine most
In
of the
order
jury,
to determine your
jurors know
eligibility to serve
something about
on
this
this
trial,
case, I'm
if
going
not
to
having
ask
watched
you
the first one.
questions, all as a group, and then I'm going to ask you to fill out a supplemental questionnaire.
Likely wish
We
they
have
would go
found
mail.
that the use of this questionnaire is helpful for several reasons. First, there are some personal questions on it, and we ask that you be candid. In addition, the process of filling out the questionnaire provides the opportunity to be more reflective as you answer the questions, rather than being put on the spot and asked to give immediate answers. After you fill out the questionnaire, we will have you come up to the sidebar one at a time so that we can follow up with you on your answers to the questionnaire and to my questions. I want to thank you in advance for your patience as we go through this process.
He was great.
As you may know, the lawyers for the parties participate in the selection of the jury. Under our law, each of the parties has the right to exercise what we call juror challenges. This means that each party has the right to challenge a certain number of prospective jurors for any reason or for no reason at all. Therefore, some of you may be excused during the impanelment procedure. If you are not selected for jury service on this case, you should not take it personally. Don't think that somehow you're not a fair person, because it's not a reflection on you at all. You will be directed back to the jury room and perhaps be picked for another case. In a few minutes, I'll pose a number of questions to you as a group. You have just taken an oath that requires you to truthfully answer these questions and all questions posed to you. If your answer to any question is yes, I will ask that you raise your hand and hold up your juror card in the air with the numbers facing out so that the court officer can read the number from the card. You don't have to get your cards out yet. I'll tell you when it's time to get your cards out.
Get your cards out.
Now, the fact that you answer yes to one of my questions does not mean that you're automatically disqualified from jury service. It simply means that there are matters that counsel and I must discuss with you. If you find a question posed to the group overly intrusive, you may elect to answer the question at sidebar. I may have additional questions for you which relate to issues that may be raised in the trial and are designed to give us information regarding your ability to serve as a fair and impartial juror in this case. And the lawyers are permitted to ask you questions for the same reason. This is not a test. There is no right or wrong answer to any question. We're simply looking for your honest and best answers to the questions.
You're lying to them. Everyone
now
knows
I'm
you're
going
lying.
to have the lawyers introduce themselves. We'll start with the Commonwealth, and when the defense introduces themselves, please introduce your client. Mr. Brennan,
Your Honor.
please.
Thank you. Good morning, ladies and gentlemen. My name is Hank Brennan. I represent the Commonwealth of Massachusetts. Along with me are two other attorneys I'd like to introduce you to.
He's special counsel brought in
To my
here.
right is attorney Laura McLaughlin. And next to me is attorney Adam Lally.
Adam Lally.
Thank you. Defense counsel,
He
please.
failed the first time.
Good morning, ladies and gentlemen. My name is Alan Jackson. I have the privilege of representing Ms. Karen Reed, who is to my right.
Good morning, members of the jury. My name is Elizabeth Little, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen of the jury. My name is Robert Alessi, and I also have the privilege of representing Ms. Reed.
Good morning, ladies and gentlemen. My name is David Yannetti. I'm an attorney. I have an office in Boston. I also have an office in Dedham.
What are you giving out
It's my
business
privilege
cards?
to represent Karen Reed.
Good morning, members of the jury. My name is Victoria George, and I have the pleasure of representing Ms. Reed.
Good morning, I'm Karen Reed. Thank you for being here.
All right, thank you very much. Folks, I'm going to read a very lengthy witness list to you. It's important that you listen to the names because at some point I'm going to ask you whether you know any of these folks. So when you hear it, please listen to it in those terms. Now, it does not mean that all 150 witnesses are going to be called at trial, but you'll hear their names if they're not called. You may hear their names during trial. So it's important that we know if you know these folks. The list is alphabetical, but it's alphabetical by first name. So Aidan Kearney from Jefferson, Mass. Dr. Aziz Wolf from South Miami, Florida. Alfredo Lopelato from Canton. Allison McCabe, also Canton. Andre Porto from the Massachusetts State Police Crime Lab. Andrew Klain from Bridgewater. Andrew Rentschler,
There's no reason to do this.
PhD from Pittsburgh. Angela Malvone from Canton. Annie Chung from Canton.
This is pretty stupid.
Anthony Flamati from the Canton Fire Department. Ashley Bell from Canton. Ashley Valliere from the Massachusetts State Police Crime Lab. Brian Albert from Norwood. Brian Albert Jr. from Boston. Brian Higgins from Sandwich. Brian Loughran from Canton. Brian Wanless, retired Canton Police Department. Bridget Meehan, keeper of the records in Canton.
I thought she was.
Caitlin Albert from Easton.
Off
Charles Ray, a lieutenant with the Canton Police Department. Chief of Police of Canton, Helena Rafferty. Chris Van E., PhD from Novi,
All right, now
Michigan.
that makes sense. She's reading off to the potential
Christina
jurors, a
Hanley
list of
from the
witnesses coming
Massachusetts
in.
State Police, Christopher Albert, Canton, Christopher Curran, Canton, Colleen Crawford from the Norfolk County District Attorney's Office in Canton, Colin Albert from Canton, Courtney Proctor from Canton, Kurt Roberts from Canton, Daniel Whitley from the Canton Fire Department, Daniel Wolf, PhD from Penns Park, Pennsylvania.
So I tried what I said
Ellington
earlier.
From Wake Forest, North Carolina. Dr. Marie Russell from Los Angeles. Dr. Elizabeth Loposada from Providence. Elizabeth Proctor from Canton. Eric
In the Alex Murdoch trial, one of the jurors was, I think, a brother of a cop who testified. And I was outraged that that guy was allowed on the jury. This is designed to sort of stop that from happening. By reading off this list of potential witnesses, now the jury would know in advance. You can't say, oh my gosh, that's my dad. He's testifying. Which would obviously impact
Knowles from the Massachusetts State Police Crime Lab.
the
Heather
juror's
Maxon
mindset.
from Walpole. Arabito Hernandez from the Boston Police Department. Holly Price from Mountain View,
Only up to
California.
H.
Ian Whiffen from Vienna, Virginia. Dr. Irene Scortibello from the Office of the Chief Medical Examiner in Massachusetts. James Crosby, master's PhD, from Jacksonville, Florida. Jason Becker from the Canton Fire Department. Jean DeMulis from Canton. Jennifer McCabe, also Canton. Jessica Hyde from Bridgeport, New York. John O'Keefe Sr. from Braintree. Judson Welcher, PhD, from a company called Aperture, LLC. Julie Albert from Canton. Julie Nagel from Canton. Dr. Justin Rice from South Weymouth. There's a juvenile whose initials are KF from Canton.
Oh, I know a
There's another
juvenile named KF.
Whose initials are PF, also from Canton.
What's the...
Caitlin Boudreau from Raynham. Karina
What's the point to
Kolakifis from Canton. Katie Camerano, also Canton. Katie McLaughlin from the Canton Fire Department. Keeper of the records for Ring from Hawthorne, California. Kerry Curran from Canton. Kerry Roberts, Canton. Kevin Albert, Canton. Kevin O'Hara from the Massachusetts State Police. Lance Mello from the Massachusetts State Police Crime Lab. Laura Sullivan from Pembroke, Laurie Cahill from Worcester, Leslie Pearlstein from Canton,
We haven't even hit the halfway
Lieutenant
mark.
Michael Lank from the Canton Police Department, Louis Jetris from Canton, Lieutenant Brian Tully from the Mass State Police,
Count Lieutenant is a first
Lieutenant
name.
John Fanning from the Mass State Police, Lieutenant Paul Gallagher from the Canton Police, Maggie Gaffney from Bonita Springs, Florida, Mark Lopalato, from Canton, Margaret O'Keefe from Canton, Marietta Sullivan from Pembroke, Mary Souza, Dighton, Matthew Amory from Canton, Matthew DeSogra from Charlotte, North Carolina, Matthew Erickson from Grosse Pointe Farms, Michigan, Matthew Kelly, Canton Fire Department, Matthew Kelsch, the Federal Bureau of Investigations, Matthew McCabe from Canton, Maureen Harnett from the Mass State Police Crime Lab, Megan Mariani from New York, New York, Michael Camerano from Canton, Michael Easter from Los Angeles, California, Michael Trotter, Canton Public Works Department, Michael Wagner from Foxborough, Mike Maroli from Bridgewater, Mike Rushworth from Thompson Station, Tennessee, Natalie Week Berschneider from San Marino, California, Nathan Reed from Raynham, Nicholas Bradford from Lorton, Virginia, Nicholas Curran from West Roxbury, Nicholas Kolakithis from Canton, Nicole Albert from Norwood, Norfolk County District Attorney Michael Morrissey, Officer Kelly Deaver from the Boston Police Department, Officer Nicholas Barrows from the Dighton Police Department, Patrick Haggerty from Somerset, Paul Mikowski from Melrose, Paul O'Keefe from Canton, Rebecca Bison from Canton, Rebecca Treyers from Norfolk, Mass, Dr. Renee Stonebridge from the Office of the
You can understand why this trial took 7 weeks.
Richard Green from St. Beach, Florida, Richard Donatino from Canton, Robert Gilman from Hull, Ryan Nagel from Canton, Sarah Levinson from Canton, Sergeant Brian Gallerini from the Needham Police Department, Sergeant Sean Good from the Canton Police Department, Sergeant Paul Giampietro from the Canton Police Department, Sergeant Yuri Buchanan from Massachusetts State Police, Shannon Burgess from South Lake, Texas, Cheryl Waugh from Canton, Sophie Herzan from the Mass State Police Crime Lab, Stephanie Devlin from the Mass State Police Crime Lab, Stephen Mullaney from the Canton Police Department, Steve Nelson from the Norfolk DA's office, Steve Bernstein, who is a keeper of the records in Stoughton, Stephen Ridge from the Boston Police Department, Stephen Seraf from the Canton Police Department, Stephen Scanlon from West Roxbury, Terry Kuhn from Davis, California, Tess Chart from Lorton, Virginia, Thomas Beatty, Canton, Thomas Kelleher, Canton, Thomas Martin, Weymouth, Timothy Nuttall from the Canton Fire Department, Tristan Morris from Easton, Trooper Connor Key for the Mass State Police, also from the Mass State Police, Trooper David DeChico, Trooper Evan Brent, Trooper Jeffrey Kostowski, Trooper Joseph Paul, Trooper Kathleen Prince, Trooper Michael Proctor, Trooper Nicholas Garino, Trooper Zachary Clark, Wendell Robery from Canton, William Reed from North Dighton. That's the list of witnesses, folks. So in a while, I'm going to ask you all if you know any of those folks. So as you can imagine, this case is expected to take a while. The lawyers tell me that once we get a jury, which may also take a while, once we get a jury, that it's estimated that the evidence in this case should take 6 to 8 weeks.
Nice.
We do our best to let you know in advance what we anticipate the length of trial will be. When we start the trial, we will go full days so that we can expedite the trial. The dates that I'm giving you, the 6 to 8 weeks, is the far end of what we expect this to be, just for planning purposes. So the days will begin at 9 o'clock. We'll take a recess at about 11 for 15 or 20 minutes. We'll go until 1. Lunch will be brought into you. We'll start up sometime around 2 and go till 4 o'clock or 4:30 every day. And there'll be days off here and there throughout the schedule, and perhaps half days throughout the schedule. So that's the schedule that we intend to keep. Now,
All
it
right.
might help you if I give you a preview right now about some basic law that applies to criminal cases like this. It's my job to teach the jury the law, and I don't do that completely until the end of the trial. So for now, I'll give you a very brief summary of some of the legal principles that govern the trial. First, and most basically,
Those faces missing glasses.
the defendant starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. An indictment is merely a formal manner of accusing a person of a crime in order to bring her to trial in the superior court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence requires you to find the defendant not guilty. The law does not require a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Another important principle of law is that the defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that she is guilty. Under our system of law, a defendant has a perfect right to say to the Commonwealth, you accuse me, now you prove it, and prove it beyond a reasonable doubt. I do not have to say a word. A defendant's decision whether or not to testify has nothing to do with the question of whether she is guilty or not guilty. The jury must not consider it in any way or even discuss it in their deliberations. Jurors in a criminal case must determine whether the Commonwealth has proved its case against the defendant beyond a reasonable doubt based solely on the testimony of the witnesses and the exhibits. That brings me to the requirement of proof beyond a reasonable doubt. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs based solely on the evidence that has been put before the jury in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. A juror's job is to find the facts. In determining the facts, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and circumstantial evidence. I'll define those terms in greater detail later, but direct evidence essentially is evidence of what a witness claims to have seen or heard or touched or somehow perceived with his or her own senses. Circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that is sought to be proved. Jurors are entitled to consider both kinds of evidence. There is no difference at all in the probative value between direct and circumstantial evidence. Circumstantial evidence is competent to establish guilt beyond a reasonable doubt. Now, I've used the word inference. An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. An inference drawn from circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one which is not too remote in the ordinary course of events. You may not guess, you may not speculate or engage in surmise. When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I'm sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we are not aware of them, and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that is what I'm talking about. We judges have the same problem, obviously, as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of on unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, consider them as individuals rather than as members of a particular group. Finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you individually and as a group do your best to resolve this case based upon the evidence and law without sympathy, bias, or prejudice to the best of your ability as human beings. Now, I know that some of this may be confusing, and perhaps all of it's confusing at this early stage of the case. You'll certainly be in a better position to understand this at the end of the case when you've heard all the evidence and I can explain the law in detail. So don't be worried if you didn't catch everything I've said. Why am I telling you these things now? Because we need to know if you are able to follow the law in this case. You don't necessarily have to agree with the law, but all the jurors will have to apply the law as I describe it.
No, I did not find my
for
glasses
jury
yet.
selection, it's important to know if any of you might have doubts whether you can accept and follow these legal rules. So I'm going to ask you questions in a few minutes. So if your answer is yes to any of my questions, please raise your hand.
And get the hell out.
Before we begin, though, I understand that sometimes jurors do not fill out the juror questionnaires completely. That sometimes we are in a rush to send them in, or sometimes we don't think that our situation applies to the question that is asked. If the lawyers and I notice that the questionnaire appears to be incomplete, we may ask you to answer the question for us.
That's our
Also,
senator.
if you know now that you failed to include information on the questionnaire, for example, a work history, prior involvement with the court, whether as a party in a case, a witness, or a juror, please let us know. So while you're taking out your cards, I will see counsel and Chief Rosen, juror number 79 too, and counsel at sidebar, please.
You're in trouble, 79. You in trouble. You in trouble, 79. Likely these jurors basically are saying, hey, we have issues with... What the heck is that? Why are you giving us this angle? Likely these jurors are basically saying, yeah, I know someone on your list there. I know someone on your list. Now, as far as like what each side is looking for here, if you're sitting there trying to get into the minds, if you're an attorney trying to figure out, okay, what kind of person, what kind of witness do I think that each side here, you know, if I'm for the state or if I'm for the defense, what type of witness are you looking for here? So ordinarily you would try to go with gender often will play a role in sculpting the mindset of an attorney, and it's an interesting thing when you're dealing with what I would call her certainly is at the very least an above average looking woman, and the natural biases that will tend to play in there. Obviously, you want your client to be someone who's going to be popular with the jury. So I would say that she's at least she's above average, depending on your take on it. No one's going to say that she's hideous, and that plays a role in your jury selection, because I guess you don't want to sit. You want to have some guys going to be sitting there looking at her googly eyed if you're the state. That's for sure. I think that she's that attractive, but I'm sure some people would say she would find her very attractive. But you certainly are going to be looking for, like ordinarily you would be thinking that if you're the state, just as far as mindset, you're going to be looking for someone who's very law and order.
So now I have questions that I'm going to ask you, and the court officers will read your number. So if you have that card, and hold it high, please. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with any of the witnesses whose names I've read? Please raise your hand.
96, 96, 32, 32, 59, 59, 3, number 3, number 83, 83.
Juror number 46, 46. Juror number 90, 90.
All right, thank you. Do any of you folks or a close personal friend or family member know, or have you had any prior dealings with the lawyers in this case or with the Norfolk County District Attorney's Office? I see no affirmative responses. Do any of you folks or a close personal friend or family member have any financial or other personal interest whatsoever in this case or its outcome?
No one's raising their hand for that
I
one.
see no affirmative responses.
No one's raising their
Has
hand for that.
anyone seen, heard, or talked about this case? Please raise your hand.
I said to jury once is enough. Now I do that again. I never have.
08, 108. Juror number 54, 54. Juror number 4. Juror number 7. Juror number 95, 95. Juror number 12, 12. Juror number 35, 35. Juror number 2. Juror number 107, 107. Juror number 41, 41. Juror number 46, 46. Juror number 24, 24. Juror number 97, 97. Juror number 23, 23. Juror number 99, 99.
Against trackers, malicious websites, and malware-ridden downloads. Get the deal now.
What's happening? What the
You
hell?
deserve a say in your health care.
What?
With WellPoints health plans, you can see a
What?
specialist without a referral.
Oh!
And there's no primary care doctor required. Your whole health is our whole point.
Possibility.
Are you kidding me? Are you kidding
At
me?
Shriners Children's, we deliver
Are you kidding me? I can't have that. What was that? Boston 10. Jeez. Unbelievable. All right. Let me see if I can dig something up here. Court TV is not covering this now. They don't care about jury selection. They're like, the hell with jury selection.
Edom native sat down with us in Houston for her first one-on-one interview with a Boston TV
What is this?
station since returning from her extended stay in space. Did you ever feel stuck?
From my perspective,
What are you kidding me? Are you kidding me? What is that? What is that? This is the stupid. Are you kidding me? Sons of bitches. You're the son. Let's see if C-SPAN's covering it. I doubt they are. It's not their sort of deal. No. No. Damn it.
And she's so humble about it, too. All right. Coming up, we're going to talk about issues with billing that could mean money back in your pocket. Yeah, the action taken against National Grid.
That's unbelievable. That's really unbelievable. That's pretty funny. That is unbelievable. Well, that's kind of disappointing. Not going to kid you. That's very, very disappointing. That is very, very frustrating. Son of a bitch. CBS Boston.
Case or in favor
God
of or
bless you.
against either of the parties. If you
Thank you,
believe that you
Phyllis.
might have a bias, please raise your hand.
Juror number 25, juror number 8, juror 90, juror 91, juror 101, juror 105, juror 65, juror number 60, juror number 115, 115, juror number 66, juror number 85.
Juror number 17, Juror number 38. Juror number 36. Juror
It's a
number
little blurrier.
37. Juror number 3.
That could be my
All right.
glasses.
Thank you. Do any of you folks have any difficulty hearing or any problem with understanding the English language, any physical or mental condition, or any religious or philosophical beliefs that would interfere with your
Court TV.
ability to hear the evidence in this case, to understand the evidence, to concentrate during the trial, or to deliberate for the purpose of reaching a verdict? If so, please raise your hand.
Juror number 95. Juror number 8.
Juror 101.
A lot of people raise their hand.
Juror number 65. Juror 105.
Juror number 13. Juror 31. 31. Juror 75. Juror 36. Juror 98.
Juror number 30.
Okay. Would any of you folks have any difficulty following the concepts that I've described? First, that the burden of proof rests entirely with the Commonwealth. Second, that that burden of proof is proof beyond a reasonable doubt and to a moral certainty. And third, that the defendant has absolutely no burden. She's presumed to be innocent unless and until the jury determines that the Commonwealth has proved its case beyond a reasonable doubt. Is there anyone who would have difficulty following those very important constitutional concepts?
Juror number 58. 58. Juror number 8.
Okay. Now, I can tell you folks that after every jury trial, I talk to jurors, and they often tell me not only that their jury experience was an interesting one, but a rewarding one.
Yeah.
I do understand, though, that for a few of you, however, service in this jury may be a substantial hardship. And let me explain what I mean by that. It's something more than mere inconvenience, because every civic duty we have causes us to be inconvenienced. It's far more extraordinary. It's something that would justify your being excused and a fellow juror having to serve in your place. I do understand, though, that it may be a substantial hardship. So if anyone has a substantial hardship, and what I typically mean by this is you have airline tickets or surgery scheduled during the course of this trial. But bearing in mind that this case may take 6 to 8 weeks to try according to the schedule that I've described, and keep in mind that I'll only excuse those who have a substantial hardship. If you think you are in that group, please raise your hand.
Juror number 97. Juror number 47. 47. Juror 108. 108. Juror number 8. Juror number 50. Juror number 7. Juror number 23. 23. Juror number 24. 24.
Juror number 90. Juror number 91. 106. 101. 34. 105. 70.
So I'll listen off those jurors there. I'm just going to point out, if you're the state, you're basically looking for someone in the. It's an interesting question with respect to given the change in administration, because I would be looking for someone who laughs at the notions of conspiracy and has a great trust in the system. So your neocons, if you can find such a thing in Boston, because most of them are all Democrats, your neocons would be great. You'd have a little bit more confidence in the jury trusting the government under a Biden administration than you would under a Trump administration, where they're distrusting. But you would think that they probably trust your local state police more. But you want someone who's basically going to blindly accept and give the benefit of the doubt to the police, because you figure that the defense here is resting most of their case on the fact that there's this whole pointing the finger that the police themselves are culpable, if not completely incompetent. The question with respect to the competence of the police is going to be a central issue throughout this trial. So you basically want people who are starting from presumption of the police are great.
But I will recess now for you to do that. All right. Thank you.
All right.
All right. Well, Joe, it's fun to see you streaming this. Makes me smile. Oh, I'm so glad. Thank you, man. If I found my glasses, I'd be a much happier camper right now. I'm not going to kid you. I would be a much happier camper. So that's the perspective of perspective of your ideal candidate. And even better if it's someone who's an ugly woman. You would be because and I'm just talking psychologically here. We're talking about different candidates. If you're the state for who it is that you would be looking to sit on that jury, if you feel like if someone was an ugly woman, you feel like sort of you sort of would I would think that a lot of them have issues with girls who grew up, that they look at her as like, oh, you grew up as a pretty girl and spoiled, or in one way or another. That's what I would think. That's what I would be looking for if I was the state. Someone who trusts the police and ugly women. And you're sort of looking the opposite end of the spectrum. If you're her counsel, if you're her defense counsel, you want someone who basically sits there and says that the government is corrupt, the police suck, and the more frustration that they have with the police, that's first and foremost. Then you can start playing into the whole gender thing, but that's where you're starting off thinking in this whole thing. Anyone who's a retired officer or something of that nature, that person becomes like a wild card. I'm not going to kid you. As far as whether for both sides, it becomes a bit of a wild card, because you sort of ask yourself, let's imagine someone was some sort of capacity. You sort of ask yourself, like, well, does that mean that they know of all the dirt out there? Does that mean that they're willing to cover up for that dirt? Does that mean that they're going to be more likely to expose that dirt and recognize how corrupt the police can be sometimes? When you're talking about military or former or cops or former cops, I think you would, as defense, I would be very nervous about having someone like that in there. Less so military than police, but that's a really, really big wild card when you're dealing with someone like that, because now you're banking on what their personal experiences were. 16 peremptory challenges. Peremptory challenges basically means I can just tell you I don't like this guy or this woman as a potential juror and knock them out. Each side having 16, that's a lot. That's a lot. Normally you have to be very strategic with your peremptory challenges because it feels like you have so few of them. When you're taking a peremptory challenge, you can always challenge anyone for cause. For cause meaning that, look, let's recognize, given the circumstances of this particular potential juror and the facts of this case, this is not someone who we can reasonably anticipate will be able to judge the facts of the evidence fairly, as presented at trial fairly, either because of some sort of bias or some sort of issue that they have. And so and you would ask the court to excuse that witness and say, hey, okay, I question whether you have capacity to remain fair and impartial, so I'm going to remove you for cause. And that would say, if you can get him out for cause, it's a witness. If it's a juror you don't like, that saves you your peremptory challenges. In the early going, the more you can save on your peremptory challenges, the more you can try and knock people off. As you start running out of peremptory challenges, you sort of get afraid, okay, who's next on the list that may be worse? However, you're sort of judging not based solely on the candidacy of potential juror, but you sort of try to bank on what's coming down, who's the next potential juror who might be filling in for the one who I'm trying to knock out now. And 16 is a lot of them. You can understand that this, I'll tell you right now, when she said 16 aside, I was like, we're gonna have a lengthy. This is gonna be at least a 2-day thing. This jury selection to be at least a 2-day deal. I can understand in a criminal trial that you would afford more peremptory challenges than a civil trial. Stakes are considered that much higher. But I've seen as few as, I think, 3. 5 or 7 is a far more common number than 16. But that could be a difference between civil and criminal. So, what do you have going on here?
You're watching WBZ News.
Cruising is projected to break records in 2025 for the third year in a row.
What the hell is happening here? I know that she went to a break. I'm assuming they're coming back. I am curious as to where you guys are at with respect to walking into this trial on thinking that she's guilty or not guilty. I am very curious about that. So I'm actually going to put up a little poll on that. Let's check that out. I take is this carried as so my take at this stage that Karen Reed is innocent, guilty, probably did it, but state can't prove it, or I have no opinion yet. Which I'll say I probably would put that out there. That's my poll out there. That's my poll. I wish that I really far prefer that they would sort of have like a camera in the courtroom and just leave it there running. Just leave it there running. We want it. I want to see Michelle woo this crazy bitch. Let's see what we got here on let me see 10. Oh, this is the one I had before. This is, look at this. The retrial Karen Reed starts today. You can watch it in the window up above. What the hell is this? This is Boston 10. Useless. So I think I'm gonna stick with it. What is that? This is the official home for the Patriots. Are you aware of juror alternate from the first trial has joined the defense team? That's correct. I covered that. Her name is Victoria something with a G. Victoria. She was an alternate and she has joined the team. And welcome, member for 1 month, Legendary Racing. I know it's not your first time. It's not your first rodeo here, but yeah, I am aware of that. I covered that very early on. You probably were not here yet when we covered that. So, see what the initial take of you guys is. All right, early voting is 60% of you thinking she's innocent, 5% guilty, 14 probably did it, but state can't prove it, and 21% saying I have no opinion. I'm definitely in the I have no opinion camp. I have no opinion at all on this. No way. No way. Morning, Sherry. What is that? They're done? They're done? You're done, CBS Boston? Really? Son of a bitch. Well, there went CBS Boston. They're done. Their stream is over. Let's see what Kurt's doing.
Find if I can maybe like put some sort of like tack on it or something, and then I can put the sticker for the watch dial on it. Maybe I can use that to apply the watch sticker. Maybe it will be better than me just doing it by straight hand. So I'm hoping that I can use this tool for that purpose as well.
That.
We'll see.
Kurt, I don't understand that.
But yeah, so all those parts are coming from China, and we'll.
Okay. My God. What's happening now?
Now let's listen in.
You're not listening in. Something's happening again. My volume's on. Let's listen in. Have you ever had a trial where you weren't allowed to state the grounds of objections in an opening court like this one? No, but criminal work is a little bit different. I think that it's kind of weird. It's kind of weird that you can't throw out. There is in criminal defense, there's a notion of not throwing out red herrings to just sort of, start planting the seed that the spaceman did it. But I don't know. I think I would have a much lower bar than Judge Cannoni seems to have on that. To be fair, she said that if you can establish at trial that enough evidence to support it. In other words, you can understand her saying, like, let's imagine that she went in there and she said Trump did it, right? Trump did it. She's got a Boston jury there. She's like, Trump's the one who ran him over. So you don't want to sort of feed like a crazy type of thought. You would want it to have some sort of legs given the evidence.
Jim, was there anything else?
So you can understand the notion of saying we don't want you throwing out something that's insane, that's likely to just sort of play into what this jury, the biases of the jury. So in case there's some people there who have issues with cops, that you wouldn't want them to just throw out there that the cops are the ones who killed him, unless you can have some threshold level there. Some threshold level. But frankly, if they are to present evidence as we anticipate they likely will be able to present, or of the nature that was presented at the first trial that Judge Cannoni said is insufficient, like there's bad evidence, and try and establish that there's a motive behind that, that it's not just sloppiness, but it was willfully corrupted. And when you see her bashed in tail light there, talking about who had access to it, or that there's residue from his drink on the tail light, which that sounds kind of crazy. Like, I'm not going to kid you, that sounds kind of insane that there's residue on his tail light from his alcohol. That sounds... So there was snow on the ground, but I guess it wasn't snowing. It's possible. You would think that would sort of... It's hard for me to imagine how, if you have a bashed taillight, there'd be residue. I'll put my drink on that.
Turn it off slowly.
Yeah, that's what I'm doing.
But yeah, so my point is, there is a notion that makes sense. I just don't know that it makes sense in this particular setting. I think that's the best way for me to answer that question as succinctly as possible. The volume levels are weird.
Can the court please stand? Hey. All persons have any business before the Honorable Sterling Kenobi, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated. Jurors remain standing. Everyone else may be seated.
I'm sorry, jurors, could either of you all raise your right hands, please? Do each of you solemnly swear to make true answers to such questions as should be put forth to you by the court to help you God?
Son of a bitch. This is the same thing from before. Jesus. It's not. No! I understand court's in recess. Yes. That would be an accurate take. That'd be an accurate take. That'd be an accurate take. I assume we're coming back. I assume they're coming back. I'm just trying to see if we can find another. I'm trying to find another. Oh, this I think is live.
And discovered the man, later identified as John O'Keefe, off the roadway in the front lawn area. Officers identified 3 women with Mr. O'Keefe, one of whom was the defendant, Karen Reed, the girlfriend of Mr. O'Keefe. The defendant had been with Mr. O'Keefe the previous evening at 2 different bars in Canton and had driven with him to this residence in the early morning hours of this date. Mr. O'Keefe was treated by paramedics from the Canton Fire Department and transported to the Good Samaritan Medical Center.
This was earlier, wasn't this?
Pronounced deceased. The Commonwealth alleges that the defendant struck Mr. O'Keefe with her vehicle earlier that morning and then left the scene while Mr. O'Keefe lay injured in the snow during a blizzard. The defendant denies these allegations. She is presumed to be innocent and has pled not guilty. So Ms. Reed is charged with second-degree murder. She is also charged with manslaughter while operating under the influence and with leaving the scene after causing personal injury or death. I will describe these indictments in detail at the end of the case when I teach you the law, but briefly, murder is the unlawful killing of a human being. There are various
This
ways
is
in which
earlier.
the
This
Commonwealth
cannot
can
be
prove
from
a
now.
murder case, and the Commonwealth is permitted to proceed under all theories it believes it can prove. Here, the Commonwealth alleges that the defendant committed murder and that the murder was murder in the second degree. In order to prove the defendant guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that the defendant committed an unlawful killing and that it was done with malice. In comparison, involuntary manslaughter is an unintentional, unlawful killing caused by wanton or reckless conduct. These
Malice,
terms and the
malice in
elements
this
of the
context doesn't mean malice. It means with knowledge. It was this mens rea, the intent to actually cause killing. That's what you need for second-degree murder, as opposed to involuntary manslaughter, which is you were drunk and recklessly dangerous, and you used your car to run this person over, leading to their death. So that's why that's considered manslaughter. Manslaughter is a reference to when you're talking about an unintentional death. So when it's unintentional, instead of it being considered a homicide or murder, we call that manslaughter. They're both homicides. Homicides, I think, incorporates both. But so you have manslaughter, so you have murder if it's intentional. If you have the mens rea, manslaughter if it was your recklessness that led to this person's death. And sometimes referred to as involuntary manslaughter because you weren't trying to kill them. Depending on the jurisdiction as to whether or not drinking changes it to involuntary or not. Yeah, I know. I'm getting that they're not live right now. I'm getting that. This is an old recording, which is just confusing y'all. It's just confusing y'all. And the reason we see these conflicting charges is because they're really not. They seem to be a little bit confused in the way they're presenting what the objective here was in the murder. On the one hand, they say, well, they had a falling out. They were having trouble. They're having troubled relationship, and perhaps she intentionally ran him over. The other is, if you don't have the intent, that maybe since they'd been out drinking early that night, that she's drunk driving, and she just didn't even realize that she hit him. So they sort of, when the state comes in with there's no witnesses, and you have purportedly her broken taillight, it's a difficult case. It's a difficult case for the state, where they don't even know if she's looking to see him dead or she was just drunk and reckless. It's a difficult case. Presenting competing theories almost seems to sow its own seeds of doubt in the minds of the jury. So if you're the state, you need to tread very carefully here to try and thread that needle, where it's like, look, we know that we know that her car, this is what the state's objective is. We want the jury to believe her car struck him. That's what led to his death through either blunt force trauma or freezing to death and hypothermia. So we're going to give you some evidence to show you that she was angry at him and had a reason to run him over, and that this was something that she wanted to see him dead. But you also sort of left with, in case you don't think that we've established that well enough, at the very least, we're hoping that the jury's going to recognize that his car, her car, she's driving, hit him. And that ultimately he's dead. And then she fled the scene. So that being the case, either this manslaughter, that she was drunk or she wasn't drunk, but she definitely left him there in a situation that was beyond reasonable prudence and showed criminal recklessness. So that's where the state's coming from here. If you're the defense, you're like, she never hit him. She never hit him, and they have no evidence that she ever hit him with the car. And the broken taillight here is all a red herring that results from them trying to frame her. So, yeah. But they're going to struggle to find a jury here, I would think, because this case was a big deal on his first go round. It was a big deal in his first go round, and so much of the public was exposed to the facts of this case, and you really can't have them coming in with preconceptions into this trial, because the idea is they need to be finding her guilt or innocence based on the evidence that's going to be presented over the next month or two. So, and for them to walk in with preconceptions is already tainting the ability to have an impartial jury. They need to be impartial walking in today. They need to be one of the 20% that answered my poll saying, I have no opinion. And hopefully not having seen any evidence at all. So if you're the state, I think you're probably a little bit concerned. Look, I think my audience is more likely to say innocent than a standard random Boston resident, because you all don't have your heads up your ass. just saying, like, you're not a bunch of lefties who are all convinced that, oh yeah, the state's doing what, the state is a trustworthy entity. But that's a very high number. That's a very high number of you who think that she's innocent. Not simply that they don't have evidence, but that she's innocent. That's a very high number. So, and they got to glean those folks out, because if one or two slip through, and that could be why there's so many peremptories. I don't know how many peremptories they had the first go round, but that could be a reason that they're like, all right, we're going to need to get rid of people. You might have concerns. We're going to have to omit some people here who have some sort of knowledge of the first trial, just because we're not going to be able to seat a full jury otherwise. So we're going to have to bring in some people here. It'll be very interesting to see how the judge handles that particular wrinkle, which could have a significant impact on the outcome of the trial. The wrinkle I'm referring to specifically is the pre-knowledge of the jury of the facts of this case, or the evidence that's presented, or maybe having watched parts of the trial in the past, and where she draws that line. Maybe if they know about it but didn't watch the trial, that's going to be deemed acceptable. I think she's going to have to draw at least that I think if she says, if you know about this case from beforehand, you're out, she's never going to see the jury. Then none of them are going to be good. And there was nothing in the setup this morning. One of the questions that the judge did not ask the jury is, do you have any familiarity with this case? Now, that's likely in the questionnaire that the jurors are answering, ask them to explain their level of knowledge and background as far as following this case. And the judge will likely go on a case-by-case basis. And question is how tolerant she will be of pre-knowledge. How tolerant she's going to be. But this is not the first time that we're dealing with a case that most of the country knows about the background of the story. We obviously saw with Derek Chauvin, we saw with Darrell Brooks. And especially when you're dealing with a local story, it's not an uncommon thing for judges having to deal with it. The only difference in this particular case is, since it's a retrial, it was that much more exposure that the public had to the actual evidence that's being presented. Meaning, if you had heard if you were brought in the Dow Brooks case, right? You were brought in as a potential juror for the Dow Brooks case. You may have seen like the video of a car crashing through a parade. You may have, you likely heard the story, but the evidence that was actually being presented, there's no chance that you would have seen it other than that actual video. Now you have people coming in here who potentially could have heard testimony on the first go round in the first trial that's affecting their perspectives on this retrial. That is something that's difficult to understand. His drink hits the tail light. I'm a little confused. Like, what position is he in that his head and his drink hit the tail light? And he has no other injuries. But let's see what the evidence presents. Let's see what they come out with. Yeah, I definitely see this going at least a week before they see the jury. I see this going at least a week, but I do think it'll be interesting to see how much patience Cannoni is going to have before she just says, just let's do it. Let's just, because the judge can take a lot of steps as far as broadening the net of who's an acceptable juror in order to push along through jury selection process. You were in a jury. Pinochet's helicopter says that they were on a jury for a murder trial in Massachusetts. We were taken in batches of 16 plus for voir dire. Well, they're taking a lot more now. They're taking a lot more because they know this is going to take a while. So, like, I'm not reading through that list of 200 potential witnesses over and over again. So. Need scholars saying, "I'm going to join the camp. I'm going to join the camp of people who don't trust the state." No, I'll tell you this much: as far as Judge Cannoni, we're talking about her patience here. It's a harsh thing to tell a defendant that they can't present a theory of the case. That's a very harsh thing. Look, they should be keeping out something that's crazy. They should be keeping out the stuff that's crazy. But to say that you can't even throw it out there that there's corruption in the police when this judge knows about some of the flaws that were evident with the investigative work of the police. I mean, you would think that the flaws that are evident are a sign of potentially it was done intentionally rather than through malice rather than through sloppiness. So it's kind of weird. It's kind of weird. The Chewbacca defense. Yes. That's what and that's essentially what you're trying to keep out when you're saying we're not letting you bring this theory in here. Right? They're trying to keep out the Chewbacca defense. It's a South Park reference to when they're basically throwing out something that's just like completely irrelevant and passionate. Let's see if we got anything. Court TV. Court TV is handling a different trial today. Court TV handling a different trial. They're handing Michigan versus Linda Sturmer. Mm-hmm. Trying to find another source here. If any of you have another source for me to check out for this trial coming back, that would be awesome. I'm not going to kid you. I'm not seeing much here. Say crime talk. All right. Fox News Live says they're covering it. I'm trying to check anywhere. Yeah.
You can see it there at the bottom left-hand side of your screen.
They have
QR
here
code. Just scan it, and it'll take you there if you want to continue to watch that session of the Senate.
Senator Booker
At the
debate.
same time, we're heading over to yet another hearing. Taking a look here, as we're seeing several Republican Congress members, they are holding this hearing for what they are calling a, quote, judicial overreach by the courts against President Trump.
By law, by the courts. Many of our colleagues are following Trump and Musk in calling for impeachment right now. There have been only 15 federal judges impeached in all of American history, always for serious professional misconduct, like taking bribes, stealing from the court, or habitual drunkenness.
Yeah, well,
not even occasional
corrupting the law is worse.
Habitual drunkenness on the bench.
Much worse than
Congress
habitual
has
drunkenness.
never defined a doctrinal or interpretive disagreement as a high crime and misdemeanor, much less when the judge's reasoning was airtight.
Airtight.
The spreading movement to impeach and attack judges is so alarming that Chief Justice Roberts issued a rare statement last week. He said, for more than 2 centuries, it's been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The proper response, of course, is to appeal the decision. And to be fair,
when it's a willful
Chairman Issa
flouting of the
expressed
law.
his strong disapproval of these wanted posters yesterday in the Rules Committee. Now, for some members, talk of impeaching these so-called rogue judges is just fun and games. But the vicious assaults, the vicious rhetorical assault on the judiciary has turned into something more sinister in certain quarters. Actual violent threats, bomb threats, direct.
I can't listen to Ratskin. I can't listen to him. Let's find something. Let's find something. We'll find something. Let's find something better to watch. Can't listen to him. His idiocy.
Wrong with expressing that opinion. Tracy says, I was called and dismissed.
Setting. What the hell is this? This is from the last trial? This is from the last trial. This is Michael Proctor. The infamous Michael Proctor. That's not helpful. What the hell is this?
One thing to do now, that's the right thing.
What the hell is this?
Stand up. What are family no issues at? What are family no issues at? We get through this.
Well, that's useless. Thought we had something. Thought I had something for you. Where was Rat Fink's outrage when SCOTUS was being threatened? Oh, yeah, I forgot. It wasn't the right people that were getting threatened. There was no outrage at all when Brett Kavanaugh was being threatened, and Chuck Schumer was threatened to bring down a whirlwind and inciting violence.
Took an international bent after I went abroad for the first time during an exchange trip to Germany with Park Ridge Junior Senior High School in 2001 and fell in love with travel. Shortly after that, September 11th happened. 7 people from my little town were killed in the towers, and we could see the smoke from ground zero from a hill in the next town blown, the next town over. For those of you who don't know, Park Ridge is very close to where I grew up, and my childhood best friend died in the towers.
No one knew that or cares.
This was why I learned how my little suburban bubble could be impacted by things worlds away. I became obsessed with trying to help and wanted to drive a career that would be in service to my country and people elsewhere so that we would be more inclined So those people would be more inclined to work with us than against us.
You think it looks like he's obviously reading a book here. You think he had ChatGPT write this for him? It's like, all right, just write over my entire life story. in all of these incidents. You think that's what he did? This was written by ChatGPT? Yeah, I know. I don't think live coverage is happening right now. I don't think it's happening. I'm starting to lose hope here. I'm not going to kid you. I'm losing hope.
Justice Kagan pointed out that, the farther it goes may create other problems.
No, I appreciate that. But how can we, if we don't say Justice Story was right, end of case, then we have to say that there is some standard that has to be met. And then we would have to explain why this case does or does not meet that standard, right? So then we have to say what the test is.
Well,
and that gets more difficult.
Yeah, well, again, there may not be one test. We laid out a test for consent. There may be a different, probably would be a different test where consent is not the basis of the jurisdiction, but something akin to minimum contacts, which I think would be a nexus to the United States, because the United States has interests abroad. If those interests are affected, like U.S. citizens or terrorism or other actions of the United States in the Middle East, if whatever.
I don't know about this case to actually weigh in intelligently on it. Numbers saying 78 indicate they've heard or spoken about the case. Candidates are filling out the questionnaire now. And that's out of how many? That's out of how many numbers? Put some Ted Daniel on X. Thank you for sharing that source with me, Numbers. Clerk told us there are 92 jury candidates in the courtroom today. 40 indicated they've already formed an opinion of the case. 16 indicated they've already formed a bias. 78 indicated they've heard or spoken about the case. Candidates are filling out the questionnaire now. That was 41 minutes ago. Judge Canoni read the names of all 150 potential witnesses. Jury candidate knows a witness, they have to disclose it. Prior to that, both sides have turned and introduced themselves to the prospective jurors. Forty out of 92. I assume it's an additional 16. Although that I'm not sure, it could be like 40 of the 40. There's 16 indicated they form the bias. So that sounds like a different thing. One has opinion, the other has a bias. 78 indicate they've heard or spoken about the case. I don't know if he means these numbers are in addition to each other for a total of 134 people. That doesn't make sense. So 78 out of the 92 have heard or spoken about the case. 78 out of 92. I'm not surprised. But basically, roughly 1/6 of them have a bias already, and 45% of them have formed an opinion of the case. She's going to have to get down to where she's going to be like, all right, can you set aside that opinion? And then depending on how convincing they are, that's what I expect her to do. Depending on how convincing they are, either say, all right, they're fine in the opinion of the court. If you want to use a peremptory on them, that's fine. But yeah, I saw that also. I was like, I don't know why he's saying it's only 92. I'm a little surprised. I'm a little confused. It could be that this is the first 92 that they're actually addressing here now. All right. I'm not gonna kid you. I'm getting a little frustrated here. Getting a little frustrated with trying to find some sort of feed of the courtroom to at least get a feel for what's happening here.
Whatever's being done has a nexus to that, that would be a sufficient basis for the exercise.
Okay, well, just to wrap up, you want on consent, you want us to say there's consent here, even though
This
there
is
might
Supreme
not
Court
be
oral
consent, or
arguments.
there would not be consent if the state tried to do something analogous and had to meet the 14th Amendment.
There may well not be, because this is conduct. The payments prong is conduct occurring
don't see it.
outside
There's
the
nothing to
United
see,
States.
but-
So if minimum contacts is thought of in terms of a territorial connection, we don't think that that applies to the United States.
Thank you.
Justice Sotomayor? Let's go back a moment to your response to Justice Gorsuch. Justice Story did not have a case in front of him involve establishing personal jurisdiction over a person who had no connection to the United States whatsoever, correct?
Right, yes.
That was not at issue there. It's interesting that he and other commentators spent so much time making these broad statements when Congress consistently, that's what Professor Sack pointed to, for over 100 years, pretty much stayed within international shoes limitations, no? In all the acts that it created.
Well, but it created nationwide service of process or even worldwide service of process, like under the antitrust laws. It has proceeded, but it has regulated some things outside the United States that affect
absolutely,
its interests.
but the absolute statement it never did.
No, it's never gone to that extent.
It's always okay. Now, going back to your concession, I think, to justice.
I'm not feeling this. All right. I'm not sure how long it's going to take them to actually work their way through this questionnaire and bring us back a feed. What I'm going to do is I'm going to come back this afternoon, and we'll see what's going on with this jury selection process. I would like to see how the judge is handling this jury selection process and these numerous issues that are developing with it. So what I plan on doing now is I'm going to shut down this stream. I'm going to come back to you for the afternoon session, and hopefully we'll actually be able to watch them questioning rather than this being off camera. And I urge you, if you follow on goodlogic.locals.com, that you'll get the exact start time. I'm expecting to come back 2:30. That's my expected time right now. But right now we're sitting here. I can't even get a feed or any sort of idea as to what time they're coming back, and it could be that they're not going to come back before lunchtime. So maybe they'll come back in 15 minutes. Maybe they'll come back. Maybe they'll come back at lunch. I don't know how long we're going to end up being here with this, but I'm going to come back to you all. I'm going to shut the stream down now, and we'll come back to this afternoon. Till then, I'll see you all later. Take care of yourselves, and Godspeed.